Speaker, I want to propose that clause 9 be deleted by inserting the words and any other benefit immediately after the word
stipend. I don't think that is his. But I don't know, Madam Speaker. I want to say I don't want actually to own this amendment because it is written there, Honorable Sunguli James,
and I'm Sunguli Julius. But anyway, pardon?
Well, will you move it as it is in the order paper?
Yes, that's
okay.
Right. So that we delete by deleting the word ready to be appearing after the word be in paragraph C.
Yes, that is what we have in the order paper.
Yeah.
Honorable members, I propose the question that clause 9 be deleted. It's not a deletion. It's actually a substitution. Honorable members, I propose the question that clause 9 be amended as proposed by the Honorable Sunkuli. I don't see any interest in this. I now put the question that clause 9 be amended as proposed by the Honorable Sunkuli. As many as of that opinion say aye. As many as of a contrary opinion say nay. There is have it. We have another one by the Honorable Gishimo on the same. On clause 9.
Yes, Honorable Speaker, I propose clause 9 be amended as indicated in the order paper by deleting paragraphs D and F. Honorable Speaker, the reason for this amendment, deletion of D, it does not make sense. The intern to be engaged in public service shall make effort to acquire relevant skills in the area of specialization. To me, that is not something that is quantifiable. How do you make effort? Of course, when you are going there, you are going to make effort to acquire relevant skills. So to me, it is superfluous, and that is why I'm seeking to delete the same. D.
I propose the question that clause 9 be further amended as proposed by the Honorable Gishimo. Honorable members, I do not see interest in this, so I move to the amendment. I now put the question that
County Assembly and the evidence adduced in support of the impeachment motion. 1. Copy of an approved notice of motion dated 11 November 2025. Copy of an approved impeachment motion containing grounds and particulars with annexures thereto. Copy of the public participation report. Copy of invitation letter to Governor to appear before the County Assembly to respond to allegations dated 17th November 2025. Copy of the County Assembly Hansard report dated 25th November 2025. Copy of division of votes list, advocates for the County Assembly, and list of witnesses. Now, pursuant to Section 33(3)(b) of the County Governments Act and Standing Order 81 of the Senate Standing Orders, at the sitting of the Senate held on Thursday, 27th November 2025, the charges against the Governor of Nyamira County, as contained in the motion of impeachment by the County Assembly of Nyamira, were read to the assembled Senate. Now, Honorable Senators, as you are aware, the mandate of the Senate in relation to the proposed removal by impeachment of a county governor is provided for under Article 181 of the Constitution, as read together with Section 33 of the County Governments Act 2012 and Standing Order 8 of the Senate, Standing Orders. In particular, Article 181 of the Constitution provides as follows. A county governor may be removed from office or on any of the following grounds. 1, gross violation of the Constitution or any other law. where there are serious reasons for believing that the county governor has committed a crime under national or international law, abuse of office or gross misconduct, or physical or mental incapacity to perform the functions of the office of the county governor. Parliament shall enact legislation providing for the procedure of removal of county governor on any of the grounds mentioned in Clause 1. Section 33 of the County Governments Act 2012, Senate Standing Order 80, and the third schedule to the Senate Standing Orders provide for the procedure to be followed in the hearing and determination of the proposed removal from office by impeachment of a county governor. Specifically, Section 33(3) and Standing Order 81B of the Senate provide that the Senate may either by resolution appoint a special committee comprising 11 of its members to investigate the matter or investigate the matter in plenary. Now, honorable senators will recall that at a sitting in the Senate held on Thursday, 27 November 2025, the motion for the establishment of a special committee was withdrawn pursuant to Standing Order 70. This paved way for the default position, the hearing of the impeachment charges against the governor of Nyamira. 2, the mode of appearance before the Senate. To the mode of appearance before the Senate, whether in person, by advocate, or in person and by advocate. 3, the names and addresses of the person in person and by advocate. 3, the names and addresses of the person to be called as witnesses, if any, and witnesses' statements containing a summary to be called as witnesses, if any, and witnesses' statements containing a summary of the evidence to be presented by such witnesses before the Senate. And finally, the evidence to be presented by such witnesses before the Senate. And finally, other evidence to be relied on. Now, pursuant to Rules 4B and 7 of the Rules of Procedure, other evidence to be relied on. Now, pursuant to Rules 4B and 7 of the Rules of Procedure, when considering the proposed removal of a governor in plenary, the Senate notify the County Assembly of the date for the commencement of the investigation. Same day, the Office of the Clerk number MNCA / Senate / 1 /2025 and dated 1st December 2025 invitation to appear issued to the County Assembly of Nyamira from Ms. Mokua Ndubi and campaign advocates who indicated that the County Assembly of Nyamira had appointed the firm to represent the County Assembly in the hearing, and that the County Assembly will equally appear in person and by advocates. The latter also indicated the list of council representing the County Assembly and the list of witnesses for the County Assembly. Pursuant to Rule 8 of the Rules of Procedure, when considered the proposed removal of a governor in plenary, the clerk of the Senate furnished each party with the documentation filed by the other party in accordance with Rule 6 and 7 of the Rules of Procedure. Now, Honorable Senators, activity displayed through the digital clocks. In summary, the program states that today, Wednesday, 3rd of December 2025, the charges against the governor as submitted by the County Assembly shall be read out to the governor. The governor will be given an opportunity to take plea on each of those charges. The governor, this will be followed by an opening statement
presented by the following council, led by myself. Elias Mutuma, accompanied by my learned friend Zelma Bonuke, Ombui Ratemo, Branly Moredi, those are advocates. Then we have Sylvia Njoki, our legal assistant, and Michelle Makandi, our legal assistant. And then we also have Erastus Orina, who is the county attorney of Nyamira County, appearing in that capacity. Thank you, Mr. Speaker, sir.
Senator Fakitui, kindly take your seat. Now, honorable senators, ladies and gentlemen, on behalf of the Senate, I welcome the team for the County Assembly. The team for the governor, members of the public and the media, to the Senate and to these proceedings. Finally, I now invite the clerk to call the next order and thereafter to read the charges.
Engage, endorse, and support unlawful, illegal, and unconstitutional bunge mashinani, directly undermine the legislative representation and oversight role of the county Assembly of Nyamira as established by the Constitution of Kenya 2010 and County Governments Act 2012, thereby constituting a gross violation of the rule of law and the principle of separation of powers. Allegation 2. Gross violation of the Constitution of Kenya 2010 by assenting to the Nyamira County Supplementary Appropriation Bill 2024 without the approval of the County Assembly of Nyamira. Whereas Article 175A of the Constitution of Kenya 2010 requires that the county government shall be based on the democratic principles and separation of powers, 2010 states that on the basis of the Division of Revenue Bill passed by Parliament under Article 218, each county government shall prepare and adopt its own annual budget and appropriation bill in the form and according to the procedure prescribed in an Act of Parliament, whereas Section 21, subsection 1 of the County Governments Act 2012 requires that the County Assembly shall exercise its legislative power through bills passed by the County Assembly and assented to by the Governor. Whereas Section 130 of the Public Finance Management Act 2012 provides for the procedures of processing a county budget, including transmission from the county for consideration and approval. 1.